Welcome back to This Week in Immigration. I'm Jordan LaPier. On the program this week, the White House's new immigration plan, the latest on cooperation between local law enforcement and immigration authorities, and why the new royal baby presents an interesting citizenship question. All that just ahead. But before we get started, please remember you can subscribe to this podcast on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. And if you leave a review, it'll help more people find our show. You can also stream This Week in Immigration on our website at bipartisanpolicy.org/podcasts. And as always, check out bipartisanpolicy.org/immigration for more information on the stories we discuss here on the show. And here with me today are Theresa Cardinal-Brown, Director of Immigration and Cross-Border Policy. She's on Twitter at BPC_T Brown. Hi, Theresa.
Hi, Jordan.
And Chris Ramon, Senior Immigration Policy Analyst on Twitter at CRamonBPC. Hi, Chris.
Hey, Jordan. How's it going?
Good. So we start off today with the new immigration plan rolled out by the White House last week with a Rose Garden speech from President Trump. Trump called for a shift to what he calls a merit-based system and away from more family-based immigration. Theresa, walk us through some of the details of this plan.
Well, details are scarce. I think that's an important thing to note about this. What we have is sort of high-level talking points and some goals that were set out in some very brief materials that the White House had. In general, what we understand is that there is to be a quote-unquote merit-based system that would shift the allocation of green cards into the United States from family-based migration, that's family-sponsored immigrants outside of the immediate family, toward more skills-based or employment-based immigration, although it's not clear how that would actually work. So what the president talked about and what has been reported is that right now our current immigration system, first of all, is based on sponsorship by someone already in the United States, whether that's a U.S. citizen or permanent resident sponsoring family members or an employer sponsoring workers. This would shift it more to a system that the immigrants themselves could look into and try to apply to migrate to the United States. And they would get points based on a set of things. So what the president talked about yesterday was age. Those who are younger, of working age, who have more time to contribute to the economy would have an advantage over those who maybe come later in life. Education and skills. It did talk a little bit about labor market and economic needs, but it's unclear how that would work. What we do know is that it would eliminate sponsorship for extended family members, so adult children of citizens and their kids. Parents might not be part of the new system. And that's about all we know. We don't have any more details than that. There's no legislative language that anyone is aware of. And in fact, even Republicans on Capitol Hill who might be supportive of this haven't seen much more in terms of details of this policy.
I think the one thing with that visa category is it's specifically called a Build America visa, which is for quote-unquote extraordinary talent, professional and specialized vocations, and exceptional academic track record. So individuals with that. So that's this new big broad visa category that they're putting all these individuals in. But once again, how are they going to determine who goes into that? What are these categories? What do they entail? I think there's a lot left that we need to learn more about.
The one thing the president did emphasize yesterday is simplification. He wanted the system to be easier for people to navigate and understand. He pointed several times to Canada, Australia models where you can literally go on the Canadian immigration website, enter some information. It would tell you pretty quickly whether or not you could qualify to immigrate to Canada. I certainly think that's a goal that a lot of people, immigrants now and their sponsors and anybody who's dealt with the U.S. immigration system now might appreciate a simpler system for sure. But again, how this would work in practice. And I also think that a lot of people on Capitol Hill, particularly Democrats, are somewhat skeptical of the shift away from family-based migration.
So there are, as the White House has pointed out, and as you said, a number of countries who use a merit-based approach. But some would point out, and I think Speaker Nancy Pelosi was among them in her remarks on Thursday after the president's speech, that merit means different things to different people. So is this proposal similar to the systems used in those other countries that the White House cites?
So a couple of things to bear in mind. One, again, no details, so hard to really do a good comparison. But it is important to understand that Canada and Australia, New Zealand, UK, other countries that were listed by the White House as models for this, on a per capita basis, actually admit many more immigrants to their countries than we do. And this particular proposal would keep the same number of immigrants as we admit now. It would simply shift them from more family-sponsored to more economic-based migration. And so that's something to bear in mind, is that these countries use their systems actually to admit a lot more immigrants on an annual basis as a percentage of their existing population than we do. And it's important to also think about how they think differently about migration. In Canada, for example, the annual number that they want to admit are called targets. They're trying to get immigrants in. We think of limitations and caps. So just the nomenclature tells you a different way that those countries look at immigration and how it supports their countries. Beyond that, you're right. There's not a universal definition of what merit means. As a matter of fact, if we go back to the polling we did last year, we asked Americans who they would prioritize in a quote-unquote merit-based system, and the criteria that they put at the top were, are they hardworking and law-abiding and trying to learn English? Nothing to do with their skills or education. Those came much lower, so even the American public isn't sure what it means when talk about merit-based immigration. So again, like I said many times here, the details haven't been issued, and they will matter in sort of understanding what this administration means by merit-based.
And I think the one thing else to keep in mind with the Canadian system, for instance, is you don't necessarily need to have a job offer in hand in order to immigrate to Canada. That's kind of towards the score that you get as you're going through the merit-based assessment process. But I couldn't see the White House signing off on a similar plan here, where I think that they would be much more apprehensive about allowing individuals to enter the United States without a job offer. So once again, more details there, but that's another point of divergence between whatever's being proposed by the White House and how things actually work in a country like Canada.
The last point I would just make is that even though if you look at as a percentage of the admissions, Canada and Australia, UK, they admit a larger percentage of their migration stream based on quote-unquote economic stream versus direct family sponsorship. If you include the families of those they admit on that economic stream and the fact that you can get points in their system for having a family already in the country, they actually do admit a fairly large number of people as a relative. So and they do admit parents and grandparents as well. So it's not directly I think, applicable, and maybe it represents sort of an oversimplified understanding of how those countries manage their migration systems.
So the lack of details aside, the White House is saying they're looking for a significant shift in how potential immigrants to the United States would get prioritized. And the numbers that they've released in terms of the share of family-based versus merit-based or employment-based immigration sort of bear that out. One question that I've been seeing is whether this would shift the decision point away from businesses and toward government as far as who can be sponsored for employment. I wonder if you've got any insights on that point.
Well, Chris made a good point. In the Canadian-Australian systems, you don't necessarily have to have a job offer, although I would say that both countries have shifted over the last decade to more of what I call a hybrid system. So again, the U.S. system, you first of all, almost always requires sponsorship by somebody already in the United States. That's not necessarily true in those other systems, although they are shifting more toward that. So in part because what they found is that without a job offer or existing family in the country to help the migrants integrate, many of them were underemployed or not necessarily employed in the area that they had skills in education once they arrived in the country. And so to counter that, they're going back toward a system that gives credit for what employers have already decided they need, rather than just the government looking at what kinds of skills might make an immigrant successful. In other words, the government deciding what makes an immigrant successful in the country isn't necessarily the best measure of how they will do over time.
And if you look at other systems, like say particularly in Europe, a lot of those are actually very similar to our system, where you need to have a job offer in hand in order to be able to work there. So this whole notion of merit-based systems where, whether or not that's like the government will be making decisions isn't universally acknowledged, and it's just simply one approach in terms of allowing individuals to come in here. There are other approaches I think that we can take cues from if we're thinking about reforming our employment-based system.
Theresa, you were quoted in an NBC News story last week about another element of the plan that we haven't touched on, and that's the need to take a civics test before coming to the United States, as opposed to doing so as part of the naturalization process as is done now. Explain what's significant about that shift.
The White House announcement indicated that it would ask immigrants to both have a knowledge of English and take a civics test before they come in the United States. Right now, we don't require either an English language test or a civics test at the time somebody gets a green card. We do require that before they get naturalized to become a U.S. citizen. So putting that up front would be a significant change. Now, there are many nations of the world that have some sort of language test before immigrants can be permanently settled in the country. That's not necessarily that unusual, but it is a little bit unusual to put sort of a civics test. A civics test is usually reserved for people who are trying to gain citizenship and trying to become a voting member of a society. So that could have a significant impact, and it's an unusual thing to ask from foreign nationals who are just coming to the country. And that could actually further reduce the number of people actually admitted to the United States if they have to take some sort of test of knowledge of the U.S. system of government and the kinds of things that we put in our naturalization test right now. That's asking a lot of people who haven't been educated in our system before coming to the United States.
Yeah, I mean, what I've been saying over the last day or so in response to this news is that, for instance, Denmark and Germany have language tests, but those are individuals who are in a specific stream, a temp to perm stream. So they arrive to those countries to work on a temporary visa, and then if they want to become permanent residents, then they have to do these integration tests. But once again, those systems are saying, okay, you can come here on a temporary basis to work. Hey, you want to stay here? You have to take this test. Whereas here, the test is right up front if you even want to arrive to the United States to apply for a green card. And I think that that's a major divergence from other systems that we've seen that.
And I think it's important to note, we heard nothing from the administration yesterday about changes to the temporary worker programs that we have in the United States. And that is a significant difference from how many of these other countries, including Canada, Australia, UK, many countries in Europe, do their immigration systems. In those countries, they do look at temporary worker programs as a stepping stone to permanent residence. So they have a more open method of moving from a temporary status to a permanent status. In our immigration system right now, temporary workers, for the most part, have a very long, arduous, and very difficult path to get to a green card if they can get there at all. And so having those kinds of integration tests at the beginning of the green card process, when you don't have a way for people to come in before then and sort of test their way in the market, makes it extremely difficult for people to enter that stream. So I think if we're going to look at those kind of tests at the time somebody gets a green card, we need to take a step back and look at how are they coming to the United States in the first place? Are we going to make it easier for people who are here on temporary basis to get into those green cards? And that's certainly the systems that those other countries that the United States is trying to compare itself to, how they do theirs.
Right, because at least what these countries do, it's almost like a dry run of your capacity to be able to integrate into these countries. I mean, obviously the assumption is that if you got a job offer in these countries like Germany or Denmark, you already are probably speaking the language, but it gives you more time to be able to integrate and to show your capacity. Whereas here, if you want to get invited to the party, you need to be able to take the right tests and be able to get in. I think that's a major divergence from all these other systems that we've seen.
I guess here's the bottom line. Is this a serious policy proposal that the White House wants to see move forward now, or is this something that the president wants to campaign on? He did say himself last week that if it doesn't get through Congress, he'll do it after the election when he believes he'll have unified Republican control of government again.
I think that's a key question. I have to doubt that it's a serious legislative proposal because there's no details and no legislative language. Nothing has been given to Congress to turn this into legislation to try to move something right now. So right now, all we have is a high-level set of talking points and some ideas. That having been said, they're not necessarily inherently bad ideas. We have been talking about different forms of merit-based immigration and comprehensive immigration reform for at least a decade. The last bill that passed the Senate in 2013 with a lot of Democrat support had the beginning of a points-based system in it alongside changes to our existing systems. So these ideas aren't by themselves sort of out of the blue. But it's notable for a couple of reasons that he did not include any information about what to do about the status of the undocumented in the United States, and particularly the Dreamers and the DACA recipients, which have been the subject of legislation over the last 2 or 3 years. They're not included in this at all. As a matter of fact, the White House said that's too divisive. We don't want to talk about that. But I have a hard time seeing how they're going to move any sort of legislation dealing with legal immigration without looking at that part of the equation as well. The other thing it's worth mentioning is that what the White House talked about was not just the changes to the legal immigration system. The president talked an awful lot about border security, changing the asylum rules. So in his mind, that's what pairs with this. And again, I don't see movement on any of those things in Congress without looking at the status of the others already in the United States.
Yeah, my question is really, who's the audience for this? That's sort of where I'm a little bit puzzled, because obviously right now we have a crisis at the southwest border. There's a lot happening there, so it makes sense that he would want to be focusing on asylum and border security, because that's something that he's been looking at for the last couple of months. But changes to the employment-based or family-based systems just kind of, we knew that this was coming down the pike. Jared Kushner had been working with a whole host of groups to sort of develop an idea, so we knew that was happening. But the timing and the audience is, definitely remains to be seen. But it could be the case that in 2020, as he campaigns, he might be messaging different components of this plan to different audiences, and that's just something that remains to be seen. Just the timing and just sort of who he's looking to sort of impress upon these ideas is just that's the open question I have, and it's a little bit unusual.
Well, and so as a campaign issue for 2020, if the president wants to say, hey, look, I'm not just all about securing the border, I have ideas for legal immigration, he now has something in his pocket. I think that does put a little bit of the onus on Democrats, if they don't like this plan, to talk about what they would also want to see in legal immigration changes. And so we'll see kind of moving forward if this prompts more discussions about what, frankly, I think has been left out of the immigration discussions for too long, which is what kind of legal immigration system do we or should we have?
Well, and that brings up a good point, and I think our polling from last year bore out that Americans do like in concept this idea of a merit-based system. If you just go on the title of it, that's something that in and of itself is quite popular.
It is quite popular, and most Americans, as our polling also said, they don't understand the complexities of our immigration system, but a simpler system does appeal to them. And so from a messaging basis, this could help the president. It absolutely could. But is it a detailed policy proposal or something that can move to legislative language? No, we're not there yet. And so to the extent that the president wants to make immigration a key issue in the 2020 campaign again, now he's got something that he can talk about. And as I said, I think it will prompt some response, I think, from the Democratic candidates and from Democrats in Congress to sort of put their own formulation on the table. One of the things I noticed yesterday, I said, if you were looking for a document that says, this is the goals and purpose of our immigration system, the president laid that out, I think, pretty clearly. What would the Democrats say in response? What would be the goals and purpose of an immigration system that they would want to see? And how does that contrast? That does set up some interesting debates for 2020.
Yeah. If anything, though, the immediate response to the plan was criticizing it, saying it's reducing immigration, it's undermining American values. These are all things that they're saying in contrast or against the plan. What is the alternative? What are they going to be doing? And I think that's something that Democrats and immigration advocates have been ignoring for a while. So the onus is on them. Are they going to take it? Remains to be seen.
All right, when we come back, the latest on cooperation between local law enforcement and immigration authorities. Earlier this month, U.S. Immigration and Customs Enforcement unveiled what it's calling the Warrant Service Officer Program. This would build on ICE's efforts to promote cooperation between local law enforcement and immigration authorities. While ICE says the new program will promote public safety, immigration advocates have criticized the initiative as an expansion of the Trump administration's enforcement efforts and a potential way ICE could circumvent state laws limiting cooperation on immigration enforcement. Theresa, how will this program work, and how will it be different than existing efforts? The 287G program, for example, already allows local law enforcement to serve administrative warrants and arrest non-citizens in violation of immigration law.
So, some of the statewide sanctuary bans actually prohibit local law enforcement from entering into 287G agreements. Now, 287G is a section of immigration law that allows the federal government to enter into agreements with state and local law enforcement agencies to perform certain immigration enforcement functions. In particular, checking the immigration status of individuals that they encounter, either in an arrest setting in a jail or during regular encounters. It can also authorize them to serve what are called immigration warrants, which is essentially a notice that immigration authorities want to detain or arrest somebody for an immigration violation. An important thing to understand about immigration arrest warrants is that they are administrative warrants. The only people authorized to issue these warrants under the immigration law are immigration officers. Some states and localities, in talking about their sanctuary policies, have said that they will not honor detainers or requests or warrants from immigration enforcement authorities unless they're issued by a judge. But there's actually no provision in immigration law for a criminal judge or a judicial entity to issue an immigration warrant. So that's an area that's still subject to a lot of debate. This particular new program would say that in jurisdictions that don't have 287G agreements, they could still authorize or, in fact, deputize single officers within those jurisdictions to serve as warrant service officers, in other words, to issue immigration arrest warrants. The Immigration Customs Enforcement explicitly said when they announced this that this would be a way to overcome some of those state sanctuary policies or local sanctuary policies. It's unclear how that would actually work in practice. It's also very unclear how much training local law enforcement officers would get to become a warrant service officer. In one piece of paper issued by Immigration Customs Enforcement, it said that the training could be as little as 1 hour, which is a very little bit of time to really understand what exactly it is that the immigration law requires of these things. In general, this has been supported by some national law enforcement agencies like the National Sheriff's Association and some law enforcement agencies in areas that have had these sanctuary policies. As you mentioned, advocates who have decried the movement of state and local law enforcement into immigration enforcement have decried this effort as well. Again, I think given the limited amount of training that goes into this and the fact that there are statewide laws sometimes prohibiting some of these practices, I think that this is another federal policy by this administration that would inevitably end up in a lawsuit.
It wouldn't be This Week in Immigration if we didn't talk about litigation.
You're right.
How big a hurdle did those state-level laws limiting cooperation present for this proposal?
Well, I think it depends on the state laws, right? So if you're looking at laws in California or Massachusetts or Connecticut, the actual language of the law and what exactly it prohibits is relevant in determining whether this particular program would violate those policies. So the initial litigation would probably come at the state judicial level because you're talking about whether or not taking part in this program would comply with a state level law. Beyond that, there are some national questions about whether or not this warrant service officer program it comports with 287G. It's meant to be sort of come under the 287G auspices without being a full 287G agreement. And so the question becomes, does federal immigration law actually authorize this kind of program? And if so, is the training that they're giving people sufficient? So I could easily see a couple of different ways this particular program would be challenged.
And I think just the one quick thing to add is this isn't the first time we've seen sort of an alternative form of trying to promote cooperation between federal immigration authorities and state and local authorities under this administration. About like a year and a half ago, there was the introduction of basically a contracting program.
The basic service agreements.
Yeah, that was introduced in Florida. Incidentally, Warrant Service Officer program was also introduced in Florida. Not sure why it's Florida, but that was another way of sort of being able to contract, jails and sheriff's offices to be able to honor ICE detainers as a way of maybe sort of circumventing some of these issues that we've been seeing around, state laws that limit the extent to which state and local authorities can cooperate with immigration authorities. So this is a trend that we've been seeing quite a bit over the last couple of years under this administration to kind of find different ways to promote that. But like as Theresa said, it's a question of whether or not litigation can demonstrate that this is a violation of many state laws that have limited this cooperation.
So we sort of outlined the complaints of immigration advocates with this proposal. How is it being received on the other side of the immigration debate, the more pro-enforcement side of the debate?
Well, there have been law enforcement agencies in states that have had sanctuary policies that have objected to the statewide sanctuary policies. They see this as an avenue to enhance cooperation that they want to engage in with the federal government. It's interesting because until the whole sanctuary debate sort of really started taking off within the last 3 or 4 years, the exact level of cooperation usually was a matter of negotiation between states and localities and the federal government. And it was typical federalism sort of negotiation. The states and local law enforcement had their priorities and their resources, and they would determine how much they wanted to cooperate with federal immigration agencies, and it was sort of left up to a local decision-making process. Now you have the influx of statewide laws that sort of absolutely prohibit or either absolutely prohibit cooperation, the so-called sanctuary policies, or state laws that ban having sanctuary policies at the local level. So you have sort of these all or nothing laws that are being passed, and the federal government coming in and saying, we think that you must cooperate with us. And that's putting a lot of these states and localities in this sort of bind of, we would like to be able to cooperate in certain areas. We don't like being forced in a position of saying it has to be all or nothing. And the pressure on these debates is really falling to the localities to try to manage amongst these differing incentives and pressures that they're feeling.
All right, up next, American royalty. Stick around. Finally today, he's 7th in line to the British throne, but Archie Harrison Mountbatten Windsor could also become an American citizen. Earlier this month, royal watchers celebrated the birth of the first child of Prince Harry and the Duchess of Sussex, the former Meghan Markle. Baby Archie is, of course, a British citizen at birth, given his royal lineage, but his mother's U.S. citizenship may also make him eligible to become an American citizen. So let's start here. What's more complicated, the rules of protocol in the British royal family or the rules governing how foreign-born children to one U.S. citizen parent can themselves become U.S. citizens?
So this has been a lot of the immigration community immediately went off on this to say, oh, well, how are the ways that that child might be a citizen or might not be a citizen of the United States? So let's go back in time. The rules about who can be an American citizen who's born abroad have changed over the last 100 or so years. There used to be lots of rules about, for example, if the parent who's a U.S. citizen is the mother versus the father, how do you claim parentage? But the way it works today for most children born abroad today, if there is one U.S. citizen parent, they can transmit their U.S. citizenship to their child as long as they have lived in the United States for at least 5 years after obtaining the age of 16 and then have moved abroad. In this case, Meghan Markle, who grew up in the United States, lived most of her life in the United States, would be able to transmit her U.S. citizenship to the child. In particular, because she is still a U.S. citizen right now, she has not formally gotten her British citizenship yet, as I understand it, and has not given up any U.S. citizenship. So that realistically would make this child a U.S. citizen at birth. There's no requirement to apply for citizenship. Archie's a U.S. citizen. The parents can choose to apply for evidence of that status by applying for a passport, a U.S. passport for the child at a U.S. embassy or consulate abroad. Or if the child comes to the United States, they could ask U.S. Citizenship and Immigration Services for a certificate of citizenship for that child.
What about British laws governing these thorny citizenship issues, and how much does Archie's royal status matter here? In other words, would things be different were he a commoner?
Well, according to U.S. law, not necessarily. British citizenship law and the inheritance rights of the royalty are a little beyond my expertise. But what I will say is that there has been concern in the past in the United States when U.S. citizens go abroad and take titles of nobility. In that case, that might cause a U.S. citizen to lose their U.S. citizenship if they took that title with the intention of losing U.S. citizenship. In this case, Archie is a dual citizen at birth. And then it comes down to whether the laws of either country would require Archie at some point in time to renounce one or the other of those citizenships. For example, if Archie were put in a position to actually take the British throne, there might be some controversy about whether or not Archie would have to renounce U.S. citizenship in order to do that. As a matter of course, right now, there would not necessarily be a requirement under U.S. law, but it might depend on what additional titles and or functions Archie takes as Archie grows up. For example, serving in the British military, getting a security clearance to do that might require that Archie renounce a U.S. citizenship. So this is one of those things that while Archie may be a citizen right now, we might watch and see what happens over time.
Why is this process so complicated? It's certainly a major contrast to the birthright citizenship rules that we have for children who are born in the United States.
A lot of it is complicated by the idea that for most countries, having a large number of its citizens living abroad who have never lived in the country is somewhat of a concern. Other countries have dealt with this as well and have, in some cases, limited the ability of transmission of citizenship to people born abroad who never then subsequently live in the country of citizenship. And the United States has wrestled with this over time. The rules, as I said, have shifted over time. Even the rules about when you can automatically lose U.S. citizenship based on activities you take abroad have shifted over time. But I think the general idea is that you want people who claim U.S. citizenship to have some allegiance to the United States. And it's difficult to say how people who have never lived in the United States might have that or demonstrate that allegiance. It's also worth noting, and this might be a very big issue going forward as to whether or not Archie would relinquish U.S. citizenship. U.S. citizens, no matter where they are born and no matter where they live, are subject to U.S. taxation. And whether or not the British royal family would want Archie to be subject to the U.S. government and IRS might in the future determine whether or not he keeps his U.S. citizenship.
Very interesting. So last question then, are we the rule or the exception here? How do other countries handle these situations?
Different countries handle them in different ways. I don't think the United States is necessarily very exceptional in this. There are some countries that do not allow transmission of citizenship to people born abroad or require some sort of special application to get that citizenship. I think we are similar to a lot of countries in the developed world in this, but every time something like this comes up, it does create a brand new debate about how citizenship is transmitted, acquired, and relinquished. I don't necessarily think we're going to be changing our laws on this anytime soon, but it does provide an interesting case study in understanding those differences. The one thing I would say is that a fallacy that a lot of people believe is that when you naturalize in the United States and take the oath of citizenship, that you automatically renounce your citizenship in other countries. Part of the oath of naturalization in the United States is saying that. But in reality, each country determines who is its citizens. So if that other country doesn't recognize that oath as automatically losing their citizenship, you could retain a different citizenship. The same is true in the United States. Just because you naturalize somewhere else or gain citizenship somewhere else doesn't necessarily mean you lose your U.S. citizenship. You have to kind of formally come to the United States and wish to renounce it. Automatic relinquishing of citizenship is something that the courts have said is very, very difficult to do.
All right, Theresa, Chris, thanks for joining me, and thanks to you all for listening. We'll be back in 2 weeks. In the meantime, please take a second to find us on Facebook by searching Bipartisan Policy Center or on Twitter at BPC_bipartisan. And don't forget to subscribe and leave your feedback on this podcast on Apple Podcasts, Google Play, Stitcher, or wherever you get your podcasts. Just search Bipartisan Policy Center. This episode of This Week in Immigration was written by Chris Ramone and myself and produced by Ashley Swearingen. That's all for now. Join us again next time on This Week in Immigration.